I thought it was abysmal.
Abysmal.
You're right. It was an abysmal performance by the prosecution today. If that's all they have, I've said it before on your show, I don't see him getting past an immunity hearing.
Benjamin Crump says, well, they didn't want to show their hand. They didn't want to show all they had.
I guess that's the best. That's a nice spin to put on it. But frankly, if that's all they have and everybody was expecting, oh, there must be more because this probable cause affidavit was so thin. If this is all they have, I don't see how this gets past an immunity hearing.
Sonny, do you agree with that?
No, I don't agree, and I'm sorry that I'm not here in New York today to disagree with Mark in person and in Technicolor. But the bottom line is this, was a bond hearing, a motion made by the defense. The prosecution relied on the affidavit for probable cause. They weren't going to tip their hand today. They were going to rely on that affidavit.
Well,
and we
Sonny,
know that
affidavit
is not a complete recitation of the facts, Mark. You know that.
You're going to tell me, based on that affidavit, that you ever thought you were going to keep him in? Everybody, there was a lot of people yesterday. All of you pro-prosecution people were all over the airwaves yesterday saying he's not going to get bond. There's a presumption, blah, blah, blah. So
not me,
explain
though.
that.
Not me.
Explain that to me.
Absolutely. Bottom line is the standard is so
Let's not all talk over each other. Because Sonny answered the question, and Mark, I'll ask you a question.
The standard is so very high for the prosecution in terms of a bond hearing in Florida. It's beyond a reasonable doubt. So I always suspected that George Zimmerman was going to get some sort of bond package. Everybody knew that.
Let me bring it, Mark Manije, the $150,000. You say that's well within the realm of where it should be. You weren't surprised by that.
Well, I was predicting that it would be about $100,000, so that's a normal realm. I would say, though, that I disagree with Mark. He classified this as an abysmal hearing. I think he's being very generous. I think that the fact of the matter is that it really didn't even rise to that level. The reality of it is they went ahead and secured, by being unprepared by their own admission, that they did not have any proof whatsoever of who initiated this or how the encounter occurred. There is no opportunity for them to come back and say that they were wrong when they swore to that. They swore to that under oath. That's all the evidence they had.
So when Benjamin Crump says, well, they didn't want to show their hand and talk about all the evidence they had, you say that you don't think that's true.
Well, as to these two key points, of course it's not true, because you take the stand and you get asked under oath, what else do you have to establish this or that, which are essential elements of this case, and they say they don't have anything else. They don't have anything else. That was said under oath.
Okay.
They can't come back and claim otherwise.
Give Mark credit. He's willing to slam the prosecutors harder than I was, and he has to practice down there.